You are standing at the edge of the Euphrates River. It is before dawn. The year is approximately 1750 BCE, and you are in the old Babylonian Empire, the most legally sophisticated civilization on Earth. You have not been convicted of anything, you have not confessed, but in 60 seconds you will enter this current, and it will decide whether you live or die. This is not a myth, this is the law. Her hands grip the wool at her sides. The fabric is thick, undyed, already heavy with morning damp. She does not look at the river, she looks at the crowd. Men she has bought grain from, women who borrowed her loom. A clay seal has been pressed into the mud at the bank's edge. Official, stamped. This proceeding is on the record. The priest stands to her left, not her husband. Her husband is somewhere behind the crowd, watching but not moving, because the law has already removed him from this equation. A neighbour made an accusation. That single act was enough. She could run. She doesn't. Running is its own verdict. The priest raises one hand, and then a voice cuts through. What you are watching is not an execution. Under Babylonian law, this is a trial. Thus, if you want to understand how civilizations buried their darkest mechanics inside their greatest achievements, subscribe and turn on notifications. This channel exists to find exactly what they tried to hide. Here is what they tried to hide. Around 1754 BCE, the King Hammurabi commissioned a legal code, 282 laws carved into a 7-foot column of black diorite. Historians call it one of humanity's greatest legal achievements. They are not wrong. The Code of Hammurabi governed wages, property, inheritance, and trade with extraordinary sophistication. It is the ancestor of Western jurisprudence. It currently stands in the Louvre, where millions of visitors walk past it every year. Or what the museum plaques do not linger on, buried between laws setting the price of silver and the daily wage of a bricklayer is a clause that gave any man's neighbour the legal power to send his wife to her death. No witnesses required, no evidence required, just the word, spoken publicly, formally, loudly, and the river did the rest. The law called it divine judgment. At the very top of the stele, carved in deep relief, the sun god Shamash extends his arm toward Hammurabi in a gesture of direct conferral. The king did not receive these laws from a council, he received them from a god, which meant questioning the law was not dissent, it was blasphemy. But here is the question that will follow us through every chapter of this story. If the river was truly the voice of divine neutrality, if the water was genuinely impartial, why did the law surrounding it work so hard to ensure certain women arrived at its bank already unable to defend themselves? That question does not have a clean answer. The answer it does have is worse than most people are prepared for. The current is wide, the current does not care, and in 1750 BCE, but the current was the final word in a legal system that had already made up its mind. The Code of Hammurabi did not treat women as invisible. That is the part historians always mention first, and they are right to mention it. Under Babylonian law, a freeborn wife had legal identity. She could own property, she could inherit, she could bring disputes before a court. Compared to many civilizations that came centuries later, this was remarkable. But legal identity is not the same as legal protection, and the difference between those two things is exactly where the trap was built. Law 128. Without a formal marriage contract, a woman is not a wife. She is nothing. Her entire legal existence rests on a document she did not write, negotiated between men, sealed before she had a voice in the proceedings. As Law 131. If a husband accuses his wife of adultery, his own wife, the woman he lives with, but has no witnesses, she may swear a sacred oath by a god and return home. The accusation dies, the matter ends. Law 132. If anyone else in the community makes the same accusation, a neighbour, a creditor, a rival, the wife receives no oath. No opportunity to swear her innocence before a god and walk free. She goes to the river, immediately, without recourse. Read that asymmetry carefully. The husband's accusation, the one made by the person who actually knows her, carries less legal weight than a stranger's public claim. The law Hammurabi built did not protect women from false accusations. It protected husbands from the embarrassment of making them, and it handed that weapon, freely, with no penalty attached, to anyone standing close enough to shout. Who stood to benefit from that? Hold that question. The answer arrived shortly, and it is not spiritual. The morning she understood what had happened, she was making bread. But the courtyard was ordinary, grain dust, the smell of fired clay, pigeons on the roof. Her husband came back from the market before the sun had fully cleared the eastern wall. He did not bring what he had gone for. He did not meet her eyes. The accusation had already been filed, not with him, with the ward administrator. The cuneiform records of the period use the word ragamu for this act. To shout a claim, to lodge a public grievance so loudly that the administrative apparatus is obligated to respond. Someone had spoken her name in the wrong register, in the wrong room, in front of the wrong official. That was all it took. She asked her husband who. He told her, not the man's name, but the shape of it. A creditor. A man her husband had lost a commercial dispute to the previous season, and a man with a debt the legal system had given him no other mechanism to collect. She had not done what she was accused of. Her husband knew it. The accusation was not about her conduct. It was about property and pressure, and the precise knowledge that Hammurabi's Law 132 had handed this man a lever that cost him nothing to pull. She looked past her husband's shoulder over the rooftop toward the western horizon, where the Euphrates moved in its ancient, indifferent line. She understood then what he could not bring himself to say. Once the public accusation had been registered, his belief in her was legally irrelevant. The community claim had superseded the marital one. The trial was already over. The river had not yet spoken, and the verdict was already set. Here is what the history books rarely discuss. What happened to the household while the woman was in the river? Surviving administrative clay tablets from Nippur, a major Babylonian city whose legal archives have been partially recovered, document property activity in the aftermath of river ordeal proceedings, remarriage occurring within seasons of a wife's condemnation, estate disputes resolved with unusual speed immediately following an ordeal verdict, commercial debt settled through the redistribution of household assets that had, until recently, belonged to a living woman. Laws 133 through 136 of Hammurabi's Code are almost never discussed alongside Law 132. They should be, because those clauses, the ones immediately following the river ordeal provision, lay out in precise administrative language exactly what happens to a wife's property and household while she is absent, while she is in the water. The legal framework for her removal was already built before she reached the bank. The system had anticipated her absence with bureaucratic calm. Scholars who have examined the broader economic context of Old Babylonian marital law have noted something deeply uncomfortable. The river ordeal, while theologically framed as divine judgment, functioned within a financial ecosystem. Creditors had motive to trigger it. Rival family branches had motive. Neighbouring claimants with unresolved property disputes had motive, and Law 132 handed all of them the same instrument, a public accusation with no required evidence and no legal penalty for being wrong. Pause on that. The woman in the river was not only a wife being judged, she was an asset being repositioned, and Babylonian law made that repositioning entirely orderly. Go back to the opening scene. The clay seal pressed into the riverbank mud, the crowd assembled at dawn, the priest with his raised hand. What you were watching was not a community bearing witness to divine justice. You were watching a legal transfer in progress. The river was not the courtroom. The river was the signature line. There is no music in this part of the story, only the sound of the current. She stands at the bank again. We are back to that moment now, but we understand it differently. The priest completes the ritual invocation to Shamash and to the river goddess, a formal prayer calling the water to reveal what human courts could not determine. The words are old, they are meant to feel old, but the ritual's antiquity is part of its authority. What the ritual does not announce, there is no standardized form for this ordeal anywhere in Hammurabi's code. The law mandates the river. It does not specify how far she must travel in the current. It does not specify how long she must remain afloat. It does not specify what threshold of survival constitutes innocence. The priest decides, the crowd witnesses, the administrator records the outcome. Her wool garments are already pulling. Wool absorbs water rapidly. Scholars of ancient textile production have documented that fully saturated wool garments of this period could retain weight exceeding 40 pounds. The Euphrates in its seasonal flow moves at speeds that could exceed 3 meters per second along certain channels. She is not swimming. Almost no one in ancient Babylon swam. And swimming was not a skill the river valley cultivated. The river was for boats and trade and gods. She enters the water. One more piece of information arrives precisely here, because the timing matters. Surviving the ordeal did not guarantee freedom. Law 132 specifies that the river decides. It does not define what survival looks like, which means the priest's interpretation of what he witnessed was, itself, the verdict. The current takes her. The chapter does not show you what happens next. The river ordeal was not unique to Babylon. Legal scholars, studying ancient Mesopotamian practice, have identified references to similar proceedings across the broader region. In city-states, in royal correspondence, in administrative records that predate Hammurabi and outlast him by centuries. The Maori letters are among the most significant of these. Recovered from the palace of the 18th century BCE king Zimri-Lim, this cache of royal correspondence documents administrative and legal proceedings across a wide swath of the ancient Near East. And buried inside that archive is a revelation that reframes everything the Code of Hammurabi presented as divinely impartial. In certain documented regional cases, while accused individuals were permitted to send a substitute into the river, a proxy, someone paid to enter the current in their place, the wealthy could purchase a stand-in. The poor entered the water themselves. The god who was supposedly rendering judgment apparently could not tell the difference. Hammurabi's specific code does not explicitly authorize proxies, but the broader regional practice exposes what the theological framing was always concealing. The river ordeal was not a system of divine neutrality. It was a tiered legal mechanism. Its outcomes were conditioned by social class, financial resources, and proximity to institutional power, like every other legal system, before and since, except this one claimed to be operated by a god. Now look at Law 2 of Hammurabi's Code. Not Law 132, Law 2 near the very beginning. Among the foundational principles, Law 2 addresses false accusers in sorcery cases. If a man accuses another of sorcery and cannot prove it, the accuser faces the death penalty. Hammurabi understood that false accusations required deterrence. He built that deterrence into the code's architecture. Law 132 contains no equivalent clause. The man who publicly accused a wife of adultery, triggering the river ordeal, initiating the property proceedings, setting the administrative machinery in motion, faced no legal consequence if she survived. If she emerged from the current and was declared innocent, her accuser walked away. The asymmetry was not an oversight. Assyriologists, who have examined the structural logic of the marital law cluster, have noted that the absence of a penalty clause in Law 132 is conspicuous, precisely because the surrounding legal framework was otherwise meticulous about symmetric consequence. She was at risk of everything. He was at risk of nothing. She surfaces. The current has carried her further than anyone expected, downstream, along a reed bank where the river slows. As her hands find something solid, she holds on. She is alive. The crowd is quiet, not celebrating, not condemning, waiting. The priest confers with two administrators in low voices. This is the moment the law does not describe. The interpretive gap where the outcome is determined not by the river but by the men watching it. She floated. She survived. What that means is now their decision. Here, for the first time in this story, both voices arrive together, because the documentary and the human record can no longer be kept apart. The narrator reads Law 132 aloud, in full translation, for the first time. If the finger has been pointed at a man's wife with regard to another man, but she has not been caught lying with another man, for her husband's sake she shall throw herself into the river. Then Law 133. Immediately after, governing the management of her household during her absence, as though the system had already scheduled it. The Euphrates spoke. But it did not speak to her guilt, it spoke to her endurance. And the law had already decided that endurance and innocence were not required to mean the same thing. The river was never designed to find truth, it was designed to find a threshold. And the threshold was one that certain women, dressed in wet wool, swept by current, watched by men with financial interests in the outcome, were never meant to cross. She climbs out of the water. She is alive. The story is not over. In some ways, it is only beginning. The Babylonian administrative record is extraordinary in its detail. Scholars have recovered clay tablets documenting grain prices by season, the daily wages of wall builders, the cost of hiring a wet nurse for an infant, the precise penalty for a surgeon whose patient died under the blade. The civilization that produced Hammurabi's code was not careless with information, it was meticulous. It recorded everything it considered worth preserving. Albeit there is not a single surviving first-person account from a woman who underwent the river ordeal. Not one. The women who did not survive left no record, that much is expected. But the women who did survive returned to a legal system that had no mechanism for recording their exoneration in the same public official register that had recorded their accusation. The accusation was administrative. The survival was personal. One entered the clay, one did not. This was not accidental. Administrative systems preserve what they are designed to preserve. The Babylonian legal apparatus was designed to document claims, transfers, debts and verdicts. The movement of assets between recognized parties. A woman who survived the river ordeal had not transferred anything. She had simply remained. And a system built around the logic of transfer had no formal category for that outcome. The accusation against her was official. Her name in that context was carved, witnessed, sealed. Her survival exists nowhere in the record. She returned home to a household whose property had already been mentally redistributed, to neighbours who had watched, to a husband whose relationship with her had been publicly interrogated in ways that left no formal resolution. The commercial dispute that generated her accusation was eventually settled through a separate property tribunal. The creditor collected, the debt closed. Her name does not appear in any document after the date of the ordeal. She does not disappear from history because she died. She disappears because the system had finished with her story, and systems do not preserve what they have finished with. The stele currently stands in room 227 of the Louvre in Paris. It is nearly 4,000 years old. It is carved from black diorite, a stone harder than granite, which is why it survived when almost everything around it did not. At its top, the sun god Shamash extends his arm toward Hammurabi. Below them, descending the column in tight cuneiform registers, are 282 laws. The stele was not found in Babylon. It was discovered in 1901 in Susa, modern-day Iran, where an Elamite king had taken it as war plunder after conquering Babylon. While whoever removed it may have intended to erase what it contained. Instead, they preserved it for 3,000 more years. The museum plaques describe Hammurabi's code as a landmark of human civilization, an early model of proportional justice, a foundation stone of legal order. This is accurate. It is also incomplete in a way that the plaques do not address. Law 132 is still there, carved into the stone. The characters have not eroded in 3,800 years. The law that sent women into the current without evidence, without defense, without a penalty attached to the man who sent them. It survived. It is climate controlled. It is beautifully lit. Approximately 1.5 million people walk past it every year. The Euphrates still flows. It runs through modern Iraq, slower now, and diminished by dams and drought, and a century of industrial extraction. It carries no memory of what it was used for. Rivers do not keep records. The women it judged left no stone. They left only the current. And the current moved on. If this story unsettled you, if you want to keep pulling at the history they taught you to celebrate without question, subscribe and stay close. There is more buried than you know. The river always moves on.